Patrick Mahomes and Travis Kelce opened a steakhouse called 1587 Prime, and they are now getting sued by 1587, which is a shoe company. 1587 Prime, the restaurant, filed their application back in August of 2023, and they filed as an intent to use, meaning that they hadn't opened up the restaurant yet, but they filed their application. And now, fast forward to today, they are registered. They have a registration certificate. The shoe company, even though they filed way later, way after, they are claiming that they were the first in use. The shoe company claims that they were in commerce since April of 2023. And this matters because the law is whoever is first in use. So if you're in a situation where you were first in use, but somebody else files before you, like for example, in this case, you have to file a lawsuit. And this is really expensive to do because it's a federal lawsuit. In other words, if you do not have a registration certificate, it's going to be an uphill battle for you. And you do have to go through this and file a whole lawsuit in order to prove that you were first in use. So if that shoe company had just filed for a trademark right when they started selling their products, they would have avoided this whole lawsuit altogether. So back to this case, argument always goes back to whether or not there is a likelihood of confusion between the two brands. And part of that analysis is looking at the goods and services and comparing whether those goods/services are related. In this case, a shoe company and a restaurant are not related. But if the restaurant does start selling merchandise such as clothing, then now we are talking more of a relation. And I believe that is what the shoe company is going to argue, because that is the only way that there could be a likelihood of confusion in this case, even though they do share the same first numbers, which is the 1587. As a trademark attorney, I do feel like this is a low likelihood of confusion, but let me know your thoughts in the comments below. Do you think that you would get confused between 1587 and this shoe company? Let me know. And as always, if you have a brand that you want to protect, schedule a call with us. That is the first step to protect your brand and avoid lawsuits like this.